While the court was unanimous, Justice Kavanaugh wrote a concurrence which Justices Thomas, Alito, and Barrett joined. I found Kavanaugh brought up a few interesting points worth looking at. I join the court's opinion. I agree that officers' actions during the traffic stop in this case should be assessed based on the totality of the circumstances. I write separately to add a few points about the dangers of traffic stops for police officers, particularly when, as here, the driver pulls away in the midst of a stop. Now, Justice Kavanaugh agrees with the court's opinion, but wants to add a few points, specifically how dangerous traffic stops are. Even for routine violations, traffic stops are fraught with dangers to police. An inordinate risk confronts an officer as he approaches a person seated in an automobile. That's from Pennsylvania v. Mims. That is in part because the officers operate at a tactical disadvantage when approaching an unknown vehicle with limited visibility and unpredictable threats. As the court noted nearly 50 years ago, a significant percentage of murders of police officers occur when the officers are making traffic stops. Traffic stops remain highly dangerous today. Now, law enforcement is a dangerous job, and within that job, I can see how traffic stops are one of the more dangerous activities we ask officers to undertake. The question is, does officer safety supersede the safety of those they engage with? What should the officer do when a driver flees from a traffic stop? There are no easy or risk-free answers. Every feasible option poses some potential danger to the officer, the driver, or the public at large, and often to all three. And an officer in that situation must make a split-second choice among those various dangerous options. Justice Kavanaugh's statement is absolutely correct. It's why law enforcement officers require so much training. In such split-second situations, there's no time to think or analyze. In these situations, officers revert to their training. Hopefully, that training would lead an officer to consider situations and possibilities before and during the encounter. So when the moment of decision comes, the reactions tend toward the best outcome. But what about when something happens that the officer is not prepared for? As happened here, the officer could attempt to stop the fleeing vehicle at the outset by jumping on or reaching into the car. The dangerousness of that option is readily apparent. Perhaps the driver will hit the brakes once he realizes an officer is clinging to the car or attempting to reach through the window. But if the driver does not slow down, then the officer may suffer serious or perhaps fatal injuries. The officer could try to fire his weapon to incapacitate the driver and bring the car safely to a stop. But the car may be just as likely to go careening into traffic, thereby threatening the safety of the officer, other drivers, passenger, and pedestrians, and more. A lot of bad situations and bad options for an officer to choose from, with no time to consider. I'm curious as to what training led Officer Felix jumping on the door sill. Of course, when an officer uses force against a fleeing driver, the judiciary still must address any resulting Fourth Amendment claim under the standard of objective reasonableness. Under this court's precedents, this inquiry involves a careful balancing of the nature and quality of the intrusion on the individual's Fourth Amendment interests against the countervailing government interests at stake. So the court sees balancing interests. On the one hand, the subject has an interest in surviving the encounter. On the other hand, government has an interest in protecting the rights of others. The court talks about a balancing, but how many courts place their thumb on the side of government's interest? How often do courts simply take the word of an officer unless there is physical evidence to contradict him? I go on. The point here is that when a driver abruptly pulls away during a traffic stop, an officer has no particularly good or safe options. None of the options available to the officer avoid danger to the community, and all of them require life or death decisions that must be made in a few seconds in highly stressful and unpredictable circumstances. I agree, there aren't any good options when a driver takes off from a stop. Of the bad options available, I think jumping on the vehicle is probably one of the worst. In this case, it wasn't Mr. Barnes who put Officer Felix in jeopardy, but his own jumping onto the door sill. But this case isn't about the traffic stop or the officer jumping on the door sill, but the reasonableness of the shot. Specifically, how do courts evaluate the reasonableness of a use of force?